Thanks everyone for joining us. We hope you are all home and cozy, enjoying our lack of snow, but keeping our fingers crossed for round 2 this afternoon. Wanted to welcome you all to the Wetlands Law and Regulation of Virginia webinar as presented today by the Waterfront Law Team and Brian Owen with MSA. We're thrilled you can join us. Before we get started, just a few housekeeping notes. If you could please make sure your cameras and your cell phones are on mute, we would appreciate it. During the webinar, feel free to ask any questions via the chat function. We've allowed for time at the end to address these questions. And lastly, we'll be recording today's webinar. So at the conclusion, please be on the lookout for our post on the Waterfront Property Law website, where we will include both today's video and PowerPoint slide deck. And now I'd like to introduce you to our host, Jim Lang. Jim is a shareholder and chief operating officer at the law firm of Pender and Coward. He focuses his practice on protecting Virginians who live, work, and play on the water. Jim established the Waterfront Property Law Practice Group at Pender and Coward. He and the 3 other attorneys in this group routinely handle all aspects of riparian property rights law, maritime and admiralty law, and environmental law. Clients consistently turn to the Waterfront team when they need help in court, at local wetlands boards, and at the Virginia Marine Resources Commission. And joining us today is Brian Owen, environmental scientist and wetland specialist with MSA. He has 15 years of environmental consulting experience and is a certified professional wetland delineator in the Commonwealth of Virginia. With MSA's Environmental Sciences Department, Brian performs research and field investigations and provides client advocacy and consultation with regulatory agencies, as well as facilitate environmental permits and prepare a variety of environmental reports. So with that, it's my pleasure to turn it over to Jim and to Brian.
Good morning, and thank you for joining us on this cold day with heavy weather predicted. And we're very fortunate today to have Brian Owen with us, a real expert in the field of wetlands law. Slide here shows you what we're going to cover today, and I'm not going to read the bullets to you, but as I got ready for this presentation, I thought about the 33 years that I've been practicing law and how this field is a little different from a lot of the others. In a lot of over my life practicing law, I've noticed that some areas of the law can be pretty simple and straightforward, and others can be pretty convoluted. And the difference in the two is when there's a lot of money at stake. And when there is a lot of money at stake, then you have people arguing over the fine meaning of words, coming up with very creative interpretations. And I think that probably applies here more so than some of the other areas of the law that I've dealt with. And you can see why that might be. If you can't get your wetlands permit, it can hang up your whole project. You can have literally millions of dollars on the line. You can have a $30 million hotel that you want to build, and it's a go, no go, depending on whether you can get your wetlands permit. And those kind of situations come up all the time in this area. And I think you're going to see that as this plays out today. But having said that, let's just jump right in. Brian, can you pick up with how to identify wetlands?
Really, the identification for wetlands was started in the 87 delineation manual, and the technical definition is provided for you on the screen, but I'll make that very simple by saying that a wetland is an area that has water present for long enough to affect the soils and the types of plants that grow there. Now, this was in the 87 manual. The Corps of Engineers has since released regional supplements to that manual. Basically, they compartmentalize the nation by its different ecoregions, and we are here in the Atlantic and Gulf Coast plain. The idea being to look at specific indicators common to those regions that can be used to identify wetlands. So that being said, every wetland has 3 common characteristics. You have to have hydrophytic vegetation, vegetation that prefers wetland conditions. There's about 700 plant species total in Virginia, so that's a lot of plants. You must have hydric soils, basically soils that have been affected by the presence of that hydrology. And again, there's a number of indicators for this region. Now, wetland hydrology, obviously you can find the presence of water there, but many wetlands dry out. And so you need to understand what those indicators are as well to identify a wetland even when it is in a dry condition. But basically for that hydrology, you have to have saturation present during the growing season for a minimum of a 2-week period.
Brian, can you jump into the Cowarden classification system?
My bad. Sorry. As far as the classification system of wetlands, Lewis Cowarden developed a system in 1979, basically categorizing wetlands into 5 broad groups. And in 1986, Congress told the U.S. Fish and Wildlife Service to use that system to map and characterize and digitize all wetlands in the United States. We'll take a moment just to quickly shoot through those 5 main categories so you can be familiar with them. Marine wetlands are the ones that are exposed to the open ocean. Now, these are, your main marine waterways. Your beaches and dunes are also regulated, but they are regulated separately and are part of that wetland system. Estuary and wetlands are as you head up into your tidal rivers and tidal streams, and these include not only the rivers and streams themselves, but the marshes that surround them. These are a mix of fresh and salt water, but still subject to the tides. As you continue upriver, you enter the riverine wetland systems. These are freshwater systems that are flowing. All of our major rivers reach a point as you head upstream where they become riverine. Again, the adjacent wetlands to those are part of that system. Lacustrine wetlands are your motionless waters, basically, more or less. These include natural lakes, of which our local lake is Lake Drummond, but they also include impounded lakes, impounded river systems, and Stumpy Lake is a great example of that. The last category are the palustrine wetlands, which are the inland wetlands. Now, these are the most difficult and complicated to identify because the types of these wetlands can vary wildly, as can the indicators that can be used to identify them. So these are the ones that sometimes can become controversial in the identification process, but also in the regulatory process as well. So why do wetlands matter? Why do we care about them? Wetlands provide a lot of functions. I'm not going to go through all of them, but basically they do store and release floodwaters. They can be used for groundwater recharge. They provide a lot of nutrient cycling properties and characteristics. They also can be used to capture nutrients for the Chesbay program requirements as well. A lot of species occur in wetlands, some only found in wetlands. And there's a lot of economic benefits to wetlands as well. Everything from fishing to rice and cranberries are 2 crops that only grow in wetland conditions. So we definitely like our wetlands, and we want to identify them correctly, preserve and protect them where able.
So wetlands haven't always been regulated. During the earlier times in this country, it was perfectly okay to expand the buildable area of your property by bringing in a dump truck and filling in that soggy area between where the shoreline is and your upland, in essence, filling in the wetlands. The Clean Water Act of 1972 at the federal level, that was the first regulation of wetlands. It's section 404 of the act, and it's tied to navigable waters. Interestingly, the word wetlands doesn't appear anywhere in the Clean Water Act. And it's turned out to be the most controversial program in the Clean Water Act. And the reason for that is it represents an extension landward of regulating land uses away from the water, which traditionally has been felt to be the prerogative of state and local government. But here you have the federal government making decisions about whether you can build a project inland or not if there are wetlands present. There are some exemptions, I've listed them there. In 1985, there was an amendment made that applies to farmers who accept agricultural subsidies. And then another feature of the federal program is the state certification. And that is the federal government acting through the U.S. Army Corps of Engineers. They're the agency that administers the wetlands program on behalf of the federal government through the Clean Water Act. They are not allowed to issue a permit if they can't get a certification from the state. And that's the state certification feature listed in that last bullet. So wetlands regulated at the federal level, but state regulation in Virginia followed, and indeed has followed in many, many states. And this is, whenever you have a federal program, sometimes state and local governments are precluded from creating a program that addresses the same topic because of the supremacy clause in the US Constitution. But in the case of the Clean Water Act, as relates to wetlands regulation, in the Clean Water Act, there's explicit language that allows the states to administer their own wetlands permit program if they want to. And so Virginia first took advantage of that with respect to tidal wetlands in 1972. And the tidal wetlands permitting program is handled through the Virginia Marine Resources Commission and the local wetlands boards. Separately, in 2001, Virginia then enacted wetlands law to address non-tidal wetlands. And that got tucked into the state water control law. I've given you the citation there. And this part of the program is run by the Department of Environmental Quality. And it enables the Department of Environmental Quality to regulate wetlands wherever they're found, regardless of whether under the federal act there would be jurisdiction. And it's administered through the Virginia Water Protection Permit Program. So Brian, can you run through how the various agencies exercise their jurisdiction over wetlands, given that you have a federal program, Army Corps of Engineers, then you have a state program with the VMRC is involved, the local wetlands board is involved, and the Department of Environmental Quality is involved.
Part of the division is figuring out which, the federal government has broad jurisdiction of all wetlands. Let's just put that out there. But the state has several different programs that divide who has jurisdiction of what. And this graphic really shows you a great example of this, where you have mean low water in your tidal zone wetlands, your marine and estuary, and everything seaward of that is under the Virginia Marine Resources Commission, and this is up to 3 miles offshore. The tide zone, so from mean low water to mean high water of a non-vegetated wetland, and if it is vegetated, it's to the 1.5 tide line. So if your tide is from 0 to 2, this would be to the 3-foot elevation mark, falls under the local wetlands boards. As you go above that, the jurisdiction falls to the Corps of Engineers, and the state would not be involved until the wetlands become isolated. Isolated wetlands are considered state waters, not federal, and so the state DEQ would be the permitting agency for those wetlands. Now, I guess one thing to add here is that depending on where your project is located, you may have to get permits from more than one of these agencies if your impact crosses multiple of these jurisdictions. So we'll get more to permitting in a minute, but I want to just put that out while you're looking at this graphic.
This next slide is a very busy one, and it reflects what I told you at the outset, which is there's a lot of money involved on the question of whether a wetlands permit is even required at a given property. And because there's a lot of money behind the answer to that question, there has been a ton of political pressure that has shown up in statutes being amended, and a ton of political pressure that has shown up in the way regulations get written, and even in the way regulations get written and then changed when we have a change in administration at the federal level. In the Clean Water Act, it is navigable waters is the key phrase, which in another part of the act is defined as the waters of the United States, which in turn is abbreviated WOTUS, WOTUS. And in the 1970s, when the Clean Water Act first came out, the Army Corps of Engineers took the approach that every wetland, wherever we find it, is subject to our jurisdiction. And if you're going to do something in that wetland, you're going to need a permit from us. And by 1985, one of those cases had made it to the US Supreme Court, and it involved wetlands that were adjacent to a lake in, I believe it was in Michigan, about 80 acres of swampland and then just soggy land transitioning to upland, where a builder wanted to build a neighborhood of homes. And the question is, do you need a wetlands permit for this part of the project that's not actually touching standing water, but just the soggy strip away from the water? And the Supreme Court said that those wetlands were, since it abuts the navigable waters, they are waters of the United States and subject to permitting. So the next case that came up, it reached the Supreme Court in 2001, involved a solid waste agency up out of Chicago, and they had bought a 500-acre piece of property that had been a former gravel pit. And throughout the property, there were little pond areas that had acquired the characteristics to be classified as a wetland. But the people who wanted to do the project said, well, this is nowhere near any of the navigable waters, so it shouldn't be considered waters of the US. And the Supreme Court agreed. They said intrastate, located entirely within one state, and isolated waters that aren't connected to navigable waters aren't subject to Army Corps of Engineer jurisdiction. You don't need a federal permit to fill those wetlands. And so the project could go forward. And then in 2006, back in front of the Supreme Court again, this time, these were wetlands that were next to drainage ditches. And then these ditches ran some distance, miles in many cases, before it reached any sort of body of water, a river and the like. And so the question is, if we're going to fill in these ditches, do we have to get a permit for that? And just as I told you, this has been convoluted. The US Supreme Court couldn't make up its mind and come up with a decision that any number of justices constituting a majority were willing to sign up to. And so you end up with these fractured opinions. And to figure out what the holding of the case is, since you had 3 or 4 different approaches being offered by the justices, you have to figure out, well, what part of these decisions do all of them have in common? And it came down to, well, there has to be a significant nexus. And oh, by the way, we, the Supreme Court, think that you, the Army Corps of Engineers, and the EPA, that the two of you should start working together and come up with, through regulation, an approach we could all agree with. And so for the next 9 years, the Army Corps of Engineers and the EPA worked on that. And in 2015, they came out with the Waters of the US rule, which lasted not at all, because the Army Corps and the EPA were sued as soon as the rule came out, and a court enjoined the application of the rule the day before the rule was going to go into effect. And so the Army Corps, because their rule had been suspended through court action, took the approach of applying the rules that had been in place before the 2015 rule, and they would wait for the court to decide whether the 2015 rule would be upheld. Well, then we had an election and a new administration came in 2016 election, new administration comes in 2017, and it repeals the 2015 WOTUS rule. They did that in 2019. And in 2020, promulgated a new rule, the Navigable Waters Protection Rule, NWPR, that and it got enjoined through court action. And so now, because the 2020 NWPR rule can't go into effect because of court rulings, the Army Corps and the EPA have said, well, we'll just continue to use the approach we were using before the 2015 WOTUS rule came out. And who knows when the EPA and the Army Corps will get a new definition of the waters of the U.S. for us. But there's so much at stake in the definitions of the Army Corps' jurisdiction here that this stuff just gets tied up politically and in courts in ways that we don't often see. Another example, when the 2015 WOTUS rule was being prepared, there's a period of time during which the public the rule will be announced to the public in draft form, and the public is given an opportunity to submit written comments about the rule. And on the 2015 WOTUS rule, there were more than 1 million comments that were submitted into that rulemaking docket and had to be considered by the agencies before they could promulgate the 2015 rule. And again, as I shared with you, as soon as the 2015 rule went final, it was sued. It was challenged in court with the result that it never came into effect. But that's where we are on the Army Corps of Engineers' ability to regulate wetlands as defined by all these jurisdictional rulings on this slide.
So what exactly is the permitting process? How do we go through this process of working with wetlands? Basically, it starts out by first identifying the presence of wetlands on the property. This is done through a wetland assessment. Walk the site, look for evidence of wetlands. A delineation is actually flagging out and mapping the limits of those wetlands. This is wetland, this is upland, and here is why. Now, any delineation that is done will need to be approved by the Army Corps of Engineers as the authority on wetlands prior to going into the final phase, which is actually permitting those wetlands. The Corps will meet on site and look at the wetlands and make an agreement, and then they issue a letter on that, which is good for 5 years, and then you can use that for permitting actions within those wetlands. And we call this a joint permit application because it is one application that goes to the Corps of Engineers, the Virginia Marine Resources, the Virginia DEQ, and also the state or the local wetlands boards. It's one application. All of the agencies can review the application, decide if if a proposed impact falls within their jurisdiction, and then what their permitting actions need to be. And I'm just showing you an example of a bridge that I permitted on a nearby subdivision. Now, as far as those permits go, there are general permits for both the Corps of Engineers. They call these nationwides. And I've listed, they've got a little over 60 of them, but I've listed the common ones that I use, including the new one, which is Nationwide 54 for living shorelines. This was a collaborative effort where the agencies wanted to streamline a permit process for living shorelines, because obviously we're trying to promote that here in Tidewater, well, really around the country. So they created that. Now, as far as the state goes, they have 4 water permits, 4 general permits. The 3 that I commonly use are the ones for utilities, for linear transportation projects, and WP4 is for general developments. This includes residential, commercial. The Virginia Marine Resource Commission and the city wetlands boards do not split out their permits in terms of general or individual permits, but both of those do typically require public hearings before they issue those permits. So we have a Virginia Beach Wetlands Board, and if a project falls within their jurisdiction, every month they have hearings, and those are presented, and the board makes a decision on those before the permit is issued. Now, general permits have thresholds, and when you cross those thresholds, they require an individual permit. I'm not going to go into those thresholds at this time, but they're very important to keep them in mind because these cost more money to do. They take more time. There's more review processes at the federal and state level to get individual permits. And these do involve a greater risk to the applicant because, we were talking about the public notice for the WOTUS rule. These are public noticed as well, and the government has to consider the comments that come in. If the public is staunchly against a particular project, they will consider that in whether or not they issue the permit. It is getting harder to keep projects out of individual permits just because if you look around Tidewater, Virginia, a lot of the good land has been developed, certainly land that has access to public utilities. And so more and more properties are being forced into the individual permit process simply because of land availabilities and also because of constraints placed on the permit process in the general permits that are allowing less and less wetland impact acreage to fall under those. Projects now more frequently exceed those thresholds. Every time that you impact wetlands, the state and federal government have a no net loss policy. We've lost a large percentage of the wetlands in this nation, and we do not want to continue that loss because of all of the benefits provided by wetlands. So they said no more net loss. If you're going to impact wetlands, you have to mitigate for those impacts. Now, this mitigation is done really in three ways. You can either purchase mitigation from a bank that was set up and designed for that purpose. These are properties that a company creates wetlands and then sells those credits. The second way is through an in lieu fee if a mitigation bank is not available. This is often the case with city wetlands boards where applicants will pay an in lieu fee for impacts, and then the city can use those fees for various environmental projects. The third option is on-site mitigation, and this is you creating wetlands on your property in another location to offset an impact. Can be a very interesting project to do. I've done several of these, but they do require permitting as part of the joint permit application, along with several additional requirements, including you have to have a mitigation plan, how you're going to design this thing, what's your success criteria, and then there's monitoring over a period of time to ensure that the wetland effort meets those success criteria. So what can you do in a wetland without needing a permit? Well, there's a number of exemptions, and two specifically is for silviculture and agriculture. If you have properties that are under these land uses, you can continue to do certain things within wetlands on those properties. There's exemptions, and I'm not going to go into all those. You can ask me separately if you like. But as long as you work within those exemptions, you can continue those properties in silviculture or agricultural uses. There's other things like, debris removal. Let's say you have a rusted car sitting in wetland and you want to get it out of there. You can remove it as long as you do it in an environmentally sound manner. This may involve something as simple as putting geotech mats on the ground so that your equipment going into the wetland does not destroy the soils. There's also maintenance, vegetation, maintenance limitations. You can do repair of existing serviceable structures, piers, docks, bulkheads, and also maintenance of existing ditches, provided that the ditch does not change its size or depth to improve the drainage from a wetland. Now, as far as what requires a wetland permit, I can sum this up very easily by saying that if you are disturbing the wetland soil disturbance, whether it's excavating or filling, or if you are destroying the wetland in some form. Now, this includes altering the hydrology, making the wetland wetter or drier, converting the wetland into a new use. If you want to turn a wetland into a farm field, again, we mentioned a little bit ago, one of the provisions that actually prohibits that, but certainly lawn space or development, those all require permits. A temporary impact would be staging materials in a wetland area. You can do it, but that has to be part of that joint permit application process if you need the wetland area for the staging of materials or equipment. Mechanized clearing of wetlands also requires, again, you can do some vegetative maintenance, but there is a limit to how much you can do. And then certainly bridges, piers, utilities, even if it free spans over the wetland, again, there's limitations, but often it requires a wetland permit.
So you've got a project, you're trying to move it forward. There's a lot of money riding on it. You've got time pressures, and you're having trouble getting your wetlands permit. So what do you do if the agency is taking a hard line with you? Well, the starting point is hopefully you had the right team going into all of this. You need a consultant like Brian on your team, somebody who understands the rules backwards and forwards and has relationships with the regulating agencies, both at the Army Corps of Engineers, the DEQ, the Wetlands Board, and the VMRC. You don't want to start one of these projects without having a consultant like Brian on your team. You might also want an attorney on your team. The thing you definitely don't want to do is the do-it-yourself approach. So the agency's given you a tough time. Your options are to keep on negotiating with them and try and get it worked out. Another one of your options is just to give in and to their demands and then get your permit. Or some people have to face the possibility that the project just isn't going to be feasible anymore with all the requirements that are being that the agency is insisting on. The project gets to a point where it's going to cost too much, or if we build it the way that they want us to build it, we can't use it for what we need to use it for. And so some people walk away from their project. But the thing I would tell you that people oftentimes overlook is that last option on this slide, which is if you think the agency is being unreasonable, you can go to court to try and get the agency's decision overturned. Now, and this brings you back to who do you want to have on your team? And I told you, you always need somebody like Brian, but this is the reason you also want somebody like me on your team, because if it gets to the point where your project is one that you're determined to see it through, even though the agency's giving you a tough time, and you're ready to go to court, you're going to invest some money to go to court. You're going to need a budget for that, and you're also going to need that project, the record put together the right way, so that all of the interactions with the agency have been put together in a way so that when you go to court, you're going to have an opportunity to get a successful outcome. Because you can have a situation where the agencies, where a court would have reversed, except that the record wasn't put together the right way in all of your dealings with the agency over the months or even sometimes years before you finally got to the point where you realized you needed to go to court. So those are the options you have when the agency takes a hard line on your project. I've got a slide here for you on enforcement. Whenever you have requirements like this that some people would view as very expensive or very onerous, they're looking for ways to not have to comply. And the Clean Water Act, the federal government anticipated that this would be the case. And so they built some pretty stiff sanctions into the act for those who try to evade the requirements of the act. And I've listed out several of them. This is by no means a complete offering, but the point here is that the regulator that you're dealing with has a lot of tools in the toolbox they can bring out to whack you over the head if you try to take the approach that says, I'm just not going to deal with you. I'm going to march forward and do what I want. The last bullet on this slide, though, is the citizens' environmental lawsuit. This is a feature that's written into many of our federal environmental laws, including the Clean Water Act, and it gives the ability for a person who sees somebody violating the environmental law, and that individual believes that the agency isn't doing enough to hold the violator accountable, that private citizen has the ability to go into federal court and sue the person that they believe is violating the law. They can, in essence, step into the shoes of the regulator. They can become the government and sue a violator and seek to have a federal court shut the violator down, impose fines over the violator, and if they prevail, recover their attorney's fees from the violator. I've been on the receiving, when I was with the government, I've been on the receiving end of citizens' environmental lawsuits. And in private practice, I've prosecuted one citizens' environmental lawsuit against a violator to a successful conclusion. We're going to wrap up with giving you a slide with additional resources on my website. And this brings us to the point of questions. Have we had any questions come in through the chat, Abigail?